Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. So you might be wondering why the mask? Well, I couldn't find my regular eye protection, and this is actually good eye protection. I've replaced the glass with much stronger lenses, and believe it or not, this rubber actually does a fair bit to stop projectiles, and that's going to be important because I've got a little airsoft range set up here because I want to do some experiments to illustrate a legal point. So I've got a backstop set up here. It's just a cardboard box with a board in it, but it's very effective. I've got a chronograph and I've got a revolver here. This is an airsoft revolver, so it's actually got some features that are quite useful for my testing purposes here. But let's just get an initial reading. Now this is in meters per second, 47.8, 53.3, 41.4, 30. That one didn't read. 32.4, and I'm out. So you might be wondering at this stage, is Runkle going to jail? Because this thing looks like a realistic revolver. It does actually match a existing model of firearm. And you can see that those are in meters per second. I don't know the exact calculation, but it's way below the eyeball puncturing stage. So I'm still wearing the mask because even if it doesn't puncture an eyeball, it would still really suck to get in the eye. But the question then becomes, wait a minute, is Runkle holding on to a prohibited replica? And is he then putting this out there as a confession for the world to see? Is some other lawyer going to be enjoying a scotch while making a video about how dumb Runkle is? Well, maybe, but I want to talk a little bit about the law here. So I'm just going to reload, I'm going to readjust and do another demonstration, and then I'll talk a little bit about the law and how this applies here. Alright, so I've got this all ready to go again. I've just adjusted here. This is a bit of an aftermarket add-on, but it's a really simple drop-in part. And this is, you can see this screw. What this modification does is it essentially adds the ability to tweak how fast this shoots. So really quickly, it took me about 30 seconds to get this all adjusted. And so now this should be firing a little hotter. Let's try it out. So that's 149.7. 148.8. 146.1. 146.7. 144.4. and 146.1. Just confirming that we're empty here. So as you can see, that airsoft gun can be really easily adjusted from firing pretty slowly and certainly well below the eyeball puncturing level that's required normally to make something not a replica, onto firing quite quickly and certainly well above that point. And I'm just going to peel this off here. I'm sure I've got terrible mask hair. Now, all in all, that took about maybe a minute, maybe 2 minutes, and that includes the time I spent hunting for the screwdriver, because it wasn't in my screwdriver bag, and it turned out, of course, that I'd placed it on the range table for convenience. So that's on me, but 2 minutes, even with that kind of screw-up, is a pretty quick turnaround. So let's, I'm going to go inside now, I'm going to look at some case law, and I'm going to talk about what this means. Because the big question here is going to be, was I holding a prohibited device, that being a replica firearm, at any point in this video? Because if I was, then I'm in a lot of trouble, and I don't want to be in a lot of trouble. So let's go have a look. All right, back inside. So let's have a really brief review of the law in terms of replica firearms and airsoft guns and how that applies. So we see here, replica firearm means any device that is designed or intended to exactly resemble or to resemble with near precision a firearm, and that itself is not a firearm. And then there's an exclusion for antique firearms, which doesn't really come up here.
So they break this down, and this is how lawyers will look at a statute, is breaking it down into sort of its component elements in order to determine what the actual legal test is here. So they note that to be considered a replica firearm, a device must fulfill the following 3 criteria. 1, must be designed or intended to exactly resemble or to resemble with near precision a firearm. 2, must not be a firearm. And 3, can't be intended to resemble an antique firearm. So then they go on and they define firearm as follows from Section 2 of the Criminal Code. Firearm means a barreled weapon from which any shot, bullet, or other projectile can be discharged and that is capable of causing serious bodily injury or death to a person, and includes any frame or receiver of such a barreled weapon and anything that can be adapted for use as a firearm. Really sort of fancy language, but really what this ends up coming down to is, does it have a barrel? Does it shoot a projectile? And is it capable of causing serious bodily injury or death, which means can it puncture an eyeball? But note also this key portion, and anything that can be adapted for use as a firearm. That's a big deal, so we'll come back to that. So scrolling down here, I'm skipping over most of this because I'm trying to keep this to be a fairly brief video. So they say, is the good in issue a firearm? In this case, it was a Walther PPK Airsoft imitation. So the CBSA submitted that the good in issue is not a firearm because it is not capable of causing serious bodily injury. It submitted that a firearm can cause serious bodily injury when it has a muzzle velocity of 366 feet per second or greater. Now, that number is debatable. We can talk about that in a different video, but that's where the CBSA sets their cutoff. And unless you bring other evidence, the tribunals are likely to accept this. So they say this standard is based on the minimum velocity necessary to rupture or penetrate the eye and has previously been accepted by the tribunal. The CBSA, I should note that the Supreme Court has actually suggested lower figures than this. So I kind of feel like the Supreme Court overrules the tribunal. I kind of think I'm right on that one, but moving on. So the CBSA relied on the test certification included in the parcel with the good in issue, which stated that it has a muzzle velocity between 251 and 275 feet per second when firing a 0.2 gram pellet, the standard ammunition used in the good in issue. Mr. Smith's report also cites numerous websites advertising Walther PPK/S pattern airsoft pistols with muzzle velocities of between 160 and 300 feet per second, and concludes that the muzzle velocity of the good in issue is unlikely to cause serious bodily injury, even if projectiles heavier than 0.2 grams are used. I would love to see the report, but I don't have that. That's not part of the decision here. The CBSA also submitted that the good in issue cannot be adapted for use as a firearm. This is relevant because if the frame of the good in issue could be used as the frame for a conventional pistol, it could be considered a firearm instead of a replica firearm. In that regard, the CBSA relied on Mr. Smith's report, which notes that the frame of the good in issue cannot be used as a frame for a conventional pistol. Now, so what they're saying here is, if you could actually convert it to being not an 84 sub 3 firearm, so one that's a standard airsoft gun, but using it as the frame for a real steel pistol. Now, it seems to me there's a big jump here. And if we look at some other cases, this is Ross in Canada. There's a bunch of them. In this case, they don't actually even consider the issue of adaptability at all. They just say airsoft gun must have a muzzle velocity in excess of 124 meters per second, and they rely on a laboratory report where they tested it and it was below 124 meters per second. But they don't actually consider the readily adaptable portion. And going back to McLeod here, scrolling up, we see that the definition of firearm includes anything that can be adapted for use as a firearm. Now, the CBSA takes the position that essentially they say we just test it as it comes in, and sometimes they don't even test it. As in the McLeod case, they sometimes just look at the documentation in it, and they say, we can't do any meddling with it. We can't do any tinkering with it. It can't be sort of fixed. The problem with this is that the law actually specifies that firearm includes anything that can be adapted for use as a firearm. And as we've seen, it may not be that difficult to take some airsoft guns and tune them up so that they now fire into the range where they are now firearms. If the CBSA got the airsoft pistol that I was using earlier, and it came in at the lower range, the 30 meters per second range, they'd say, this is a prohibited device, this is a replica firearm, and we are going to seize it. But if they saw it at the higher end of the range, they'd say, you're good to go. That's perfectly legal. And all that it takes is turning a little screw. As I said, under 2 minutes, even with me misplacing my screwdriver. So that is something that the court is going to find can be easily adapted to be used as a firearm. CBSA is not doing this with airsoft guns, and they really need to be, because something that comes in shooting at 300 feet per second, but can easily be turned up to shoot at 400 feet per second, is in law a firearm. And they're saying it's not, and that makes it a replica. So what the CBSA argues is that they have to take these goods and look at them in the state as they are when they arrive at the border without doing any modification. The problem with that is that the legal state for an airsoft gun is if it can be adapted for use as a firearm, then it is a firearm. So that legal state of adaptability should be enough to make it legal, but they're failing to take that step and to make that consideration. And I haven't seen any case law actually on this point, but in my view, the CBSA and the tribunal seem to be missing this. The one decision, the McLeod decision, they consider it, but they consider it wrong. They say, could you make this into a real steel firearm? When really what they should be asking is, could you tune this up and make it into an 84 sub 3 firearm by increasing the velocity? Now you might be saying, well, the CBSA's got this policy, that's just how they do things. But that's not how they do things when we get into other categories. If, for example, you were to ship a handgun from the States, like a real steel actual handgun, and you just pulled the firing pin out, they would certainly say this is a firearm because it can be adapted for use as a firearm just by putting a new firing pin in. If you disassembled it and shipped it as a box of parts, same thing. If you tried to import an 80% lower from the States, if you don't know what an 80% lower is, it's essentially an almost finished AR-15 receiver, but in its sort of 80% state, you can't, it doesn't work as an AR-15 lower. You got to do some additional work on it. But they would certainly take that and look at it and say, well, this can easily be turned into a proper AR-15 lower, and therefore it can be adapted for use as a firearm, and therefore it's a prohibited firearm because, of course, they banned the AR-15. So the failure to look at that and the failure to do that with respect to airsoft guns appears to me to be a wide and sweeping misapplication of the law. I haven't seen anyone argue this in any of the case law I've been able to find at the tribunals, but it's a big issue. Part of the problem with the tribunals is that they're typically self-represented individuals as opposed to people hiring counsel. And the reason for that is that if you're looking at, you've ordered a $300 airsoft gun, maybe a nice one. There's much nicer airsoft guns than that, but, let's say $300 and it gets seized. If you walk into a lawyer's office and say, how much law can I get for $300? You're probably going to be told, not a whole lot of law for that much. So people don't hire lawyers for these. And they don't realize that the burden of proof is actually on them in these trade tribunal procedures. So there's a lot of situations where people just didn't bring the evidence that maybe they should have. But it seems to me that this is ripe for a proper challenge. This is an area where there's the potential, at least, to get these trade tribunals to maybe apply the law in what I think is the proper way. Anyway, that's sort of the long and short of it. I think, one person asked me what happens if I tune my airsoft gun down. It's come in over the border at 450, but I'd rather shoot at 300 on my range. So long as it can be adapted back up, the definition of firearm should say that that is fine. However, should is a big thing, because you could end up with a provincial court judge deciding to apply these trade tribunal decisions, and then you've got a problem. The other thing I will note that's worth considering here, and that is in terms of the definition in the 84 sub 3 section, because that can be adapted for use as a firearm. That language is found in section 2 as to what counts as a firearm. However, and I'm just bringing it up here, when we pull up section 84 sub 3, just going to switch us over. All right, the certain weapons deemed not to be firearms. It says any other barreled weapon where it is proved that the weapon is not designed or adapted to discharge. And then they give the speed and the muzzle energy aspects. But there's no can be adapted. So for this section, it seems like you take the firearm as it is in its current state. And so, you know, you couldn't consider the question of, let's say I take this t-shirt cannon and really put it into overdrive and see how fast it can possibly go. You have to look at it in its current state. But in terms of whether or not something is a firearm versus a replica, that can be adapted portion is in there and is very much, in my view, an essential portion there. And yeah, so that's essentially why I think the CBSA is seizing way too many airsoft guns that should otherwise be coming into Canada. But that'll be an issue ultimately for the courts. And until it's argued, it's just academic, my hypothesis here. Thank you for watching. I hope this has explained, for instance, how some fields can have like a maximum 350 feet per second rule. And I also hope that this has provided some information about the CBSA and their seizures and why I think they're overseizing things. I'm hopeful that maybe getting this information out might change things, but in order to do that, there's going to have to be some processes brought with lawyers and with proper evidence and argument, because this is going to be a complicated issue. Maybe one of the major importers will take this up, but we'll see. I also want to thank my Patreon supporters at the $50 level, DMO, People of Canada, Sir Daniel Wicks of Alberta, and Canada's National Firearms Association. At the $20 level, Cameron Johnson, Kevin Fleet, Dale Nesbitt. And at the $10 level, Mabadi Keith, Process Eng, Stephen Larson, General Counsel of the CCFR, John Robinson, TR, Roy Haddock, Fracklesdack, Jean-Alexandre Tessier, Sir Goat, Sights and Arms Limited, Chaba Hollow, Peter H., Craig Kwan, Akin Coxall, North Central Process Service, Toys Are for Boys, Ian Vaughn, Milan Vrekic, Terrence Griffiths, Doug Thompson, Mark D., Brad Crooker, Jason Harrington, Lee Kiso, Mark Stout, Michelle Stotzel, Scott Sweetman, Mike Rhodes, DF, Stacey Cartmell, Tactical Advantage TV Canada, Ian S., Dave Leslie, Juan, Donald Duncan, Darren Duell, Sean Crane, Ian Hutchinson, Rory, Travis, BC Bushcraft Leather, John Singarty, Misa Komarevich, All Systems Go, David Moga, Ian Hedge-Danek, Hello from Venezuela, Taylor Delnea, Rod Gusman, Matthew Nesbitt, and Conway Yuri. Thank you once again, and I hope I've armed you with knowledge, and I hope that this might be a step towards getting some change in this area. Thank you, and see you next time.